the Brigham Young University Family History Library webinar series. Feel free to use the chat box for any questions. If we are unable to get to them during the presentation, they will be answered at the end. My name is Braden Knudsen. I will be your host for this webinar. Today we will be pleased to hear from James Tanner, who will be giving a presentation titled Critically Examining Wills for Genealogy. James Tanner has a bachelor's degree in Spanish and a master's degree in linguistics from the University of Utah. He received a Juris Doctor degree in law at Arizona State University. He served for 2 years as an intelligence analyst for the U.S. Army and 39 years as an Arizona trial attorney. He has previously owned a retail computer business and an Apple Macintosh software company. James has over 32 years experience in genealogical research and is an avid blogger of Genealogy Star blog and Rejoice and Be Exceeding Glad. He served for 10 years as a missionary at the Mesa, Arizona Family Search Library and is currently serving at the BYU Family History Library. He has presented at expos and conferences around the U.S. and Canada. James has 7 children and 33 grandchildren.
Howdy, this is James Tanner, and we're here at the BYU, or Brigham Young University Family History Library in Provo, Utah. And this particular series of webinars is being recorded, and the recorded webinars are being uploaded to the BYU Family History Library YouTube channel. So you can go back and review the over 150 audio recordings, video and audio recordings that we have uploaded previously. Today we're going to talk about critically examining wills for genealogists, and we'll get right into it. First of all, we have to recognize that the language of a will goes back a long time back into antiquity. If you took a will that was written back in the 1700s, it would sound very, very similar to one that was written today by an attorney in wherever part of the United States or in England or wherever they were writing still in English. So what we're going to talk about today is the form and language, as how the form and language are governed by the law of the place where the will is or was made. So what this means is that if you make a will in Arizona or Utah, then the law of Arizona and Utah governs how that will would be affected by the laws of the state. If you have a will, what happened, for example, many times in the past with me was that Arizona is kind of a winter vacation place where people would come for winter visitors to, particularly to Mesa, where the population would almost double every winter. But where our offices were in Mesa, we had a lot of these people from out of state. And since they were winter visitors and usually retired folks, it was not unusual to have a few of them pass on. And if we were doing the probate of the will would be probated in Arizona if they died in Arizona. However, some of these wills were written in places that were not necessarily have the same laws as Arizona, such as some of the eastern states. And so there were sometimes provisions of the wills which were surprising. And in those cases, the court would have to look at the law in the place where the will was written in order to determine how to construe, that would be the technical term, or determine what the provisions of the will were intended by the person who had made the will. How this affects genealogists is that the genealogists whose ancestors come from a variety of places, particularly in this case in English-speaking places or even where they speak other languages in Europe, in order to determine exactly what happened with the will, how the provisions of the will may have affected the distribution of the property of the deceased person, it's going to be necessary to go back and study the law that was applicable at the time that the will was written in the place where the will came from. In other words, you're not going to look at a will written in the 1700s even though it looks very, very similar to a will written today in the United States or in a state like Utah, you're not going to be able to use the same law that you have today in Utah to determine how that will may have been applied by the court at the time. So there's a measured degree here of historical research that needs to be done into the legal environment of the will at the time that the will was created. In the United States, we can refer to primarily where we're going to see wills that you're going to find more commonly are those that were written in either the 19th or 20th centuries. And in this case, there are some helps. In this particular one, there is the Library of Congress, and it goes through a summary here on of the inheritance laws that were in effect in the 19th and 20th centuries, and gives kind of a summary of that. And this is a good place to start getting some background in the history of the law as it applies to wills, and particularly as it may affect how the wills are operated or what they did at the time that your ancestor wrote that will. And it's important to understand that in the United States, at least, inheritance is a matter of state law. There are no general federal provisions having to do with inheritance or with the making of wills. So each state has a unique and almost, in a lot of them are quite distinctive methods of applying the language that goes into a will. Starting back in the about 1970 and 71, the United States began, some of the states in the United States began accepting what's called the Uniform Probate Code, which also affected the making of wills. The Uniform Probate Code was created by a committee of attorneys and judges and other legal scholars. And what they do is there's a commission on uniform laws that basically goes around and creates laws that they think should be applied across the board, all across the United States. And then they propose this to the various states, and then the states, various state legislatures have to decide whether they want to adopt the Uniform Code. There's Uniform Code for personal injury, there's Uniform Code for all sorts of different kinds of law. In this case, the Uniform Probate Code was accepted and adopted in Arizona about the time that I was in law school, back in the 1970s. And so I became very, very familiar with it. It also is in effect, by the way, in part in Utah. But over the intervening almost more than 40 years since the law was adopted, both Utah and Arizona have made major changes to the Uniform Code. So now it's not anywhere near uniform. So we just have to understand that even at more recent attempts at trying to make these the various laws of inheritance across the country a little bit more understandable and uniform have not been very, very successful. As we go on here, another place where you might go to look for information about the general structure of wills is American Bar Association, and they have an introduction to wills and talks about the different procedures and things. Now, notwithstanding what I just said about the differences between the various states and particularly the changes in the law that have been attempted over time, the law concerning inheritance and concerning wills is extremely conservative. When we talk about changes to the inheritance laws or making uniform laws of inheritance, the changes are almost imperceptible. In other words, what is considered a radical change when you talk about the law of wills or inheritance is something so hard to understand and minor in some cases that you really have to be very well into and educated, because there is no way in the world that they're going to start to affect the way that your will that you've already done and that you've already made would be changed in any radical way. And this goes back, if you keep doing this, it hands itself off going back all the way into hundreds of years. In fact, there were wills that have been discovered that were written on pottery shards in Hebrew back before the time of Christ, and they are recognizable wills. And so these things are things that don't really change a whole lot. Now, one thing that you kind of have to start getting some language here. If you have a will and you die, well, everybody does, but if you have a will and when you die, then you are considered to have died testate. Now, all that word means is you had a will. And if you did not have a will, then you the term is intestate. So when you hear about whether someone died testate or intestate, it just all that means is they had a will or they didn't have a will. Now, these are some of the most specific things that need to be reviewed in order to have a will. In other words, if I'm going to make a will, there's like a checklist of legal things that I have to touch or do or talk about in my document before anyone anywhere will consider it to be a will. So there's what are called formal prerequisites. And the first one of those is you have to have a statement of the name of the testator. Now, the testator, in this case, the word testator means the person who is making the will. So we need the statement of the name. So usually the will starts out with something like, this is my will, James Tanner, etc. If it doesn't identify the testator, the person making the will, then you have a real problem. That's kind of the basic threshold to having a valid will. Secondly, the person making the will has to make some expression of a desire to dispose of the property upon death. This is called the testamentary intent, and this is very, very important also. Any document that purports to be a will has to very much express testamentary intent. And it has to be in language that's specific enough that a court would recognize this as being the will of the person or what the person would like to have happen on their death. It can't be something about, well, I'd like to give $100,000 to my daughter, and signed it by James Tanner. That would never be construed as a will, because there's no intent showing that I wanted that gift, or that it would be called a bequest, that gift given to my daughter on my death. And if that doesn't happen, and if those words aren't available, then there is a major issue as to whether the document is actually a will. Now the question becomes, kind of get raised at this point as to what about wills? How do we determine that they are a will? Well, we have a process that we go through in courts called probate, and the basic concept there is to determine whether or not a person had a will or didn't have a will. In other words, did they die testate or intestate? And if they did have a will, to determine if the document that they have before the court is actually a will. Now, today, if you went to an attorney and he drafted up a will and charged you a few $100 for the process, and then you took that, and then after you died, if your heirs took that to court, the chances that would not be construed as a will would be virtually impossible. In other words, somebody would, unless there was some real serious challenge to the validity of the will, most wills are just accepted as a matter of course. But it isn't that unusual. In my years of going to court over probate matters and being involved with wills and the situation, there were a number of challenges to the validity of a will based on the language and based on the lack of touching base to each of these various provisions. The next one here is a statement revoking any prior wills, whether or not there were actually any. It doesn't really matter if you have a prior will. A good will drafter today would always include this. Now, if you go back in time to old wills, this is a rather recent provision. The wills, as they were made historically, were done what we call in extremis, meaning the person thought they were going to die, and so they made a will. And they're generally, the wills are dated very close to the date of death of the testator. This is not the case today. We now have a whole world, I guess you would call it a large commercial interest in getting people to make wills, even if they don't need them, and even if they're too young to even start thinking about their demise. And even if they don't have a significant enough estate to worry about who's going to get it. There are a lot of questions you need to ask. Some of my contemporaries out there in the law did a pretty good business of just going around and giving little seminars. In fact, you may have gotten, like I have within the last week or so, a notice in the mail inviting you to a free luncheon where you can come and they'll tell you why you need a will and why you need to buy their insurance and all that. The answer was that I was almost never invited to those particular proceedings for the simple reason that I would tell people they didn't need wills. And there were a lot of times that I would say, tell me, answer these 5 questions, and I would ask 5 questions, and then I would say, well, sorry, but I don't think you need a will. But you can have one if you want. I'd be glad to charge, like $300 or $500 or whatever, and I'll write one up for you. But this is kind of the kind of thing. But in most of the cases that are involved at the time historically, and if you go back in the wills today, most of the property that was a concern at the time that it passed from a deceased to the deceased heirs, the people who inherit the deceased property. Those back in historical times, there was a concern because there were taxes on a lot of different items. There were pin taxes, pins like the kind you pin clothing with. There were window taxes. There were all sorts of interesting things historically. And so these things were a matter of concern. Today, the level of taxation on estates in the United States is relatively high. That changes every time the legislature goes into session in the United States and imposes new tax rates, but it is high enough that most of the people in the United States die without ever having to worry about paying any estate taxes. And so wills today have become very general, mostly referring to all of my personal property as one particular item, whereas in the inventories that were done with the old probates, it was not unusual to see people counting teaspoons and looking at individual items that were passing. The next thing is a reference or a list of the testator's property and the disposition of the property. This can be general by saying something like, I leave all my personal property to my wife, or it could be as specific as a list detailing each item of personal property that was owned by the testator. One of the things that you're able to tell from this generally is what the testator's economic status in the community was, because you can see exactly how much property they owned. Historically, though, it would seem that they owned very little, unless you get into the context of the will back at the time that it was written, and you may find out that your ancestor was quite wealthy compared to the other people in the community. And then they need to dispose of all the remaining property, anything that isn't listed. The problem that occurs with a will that isn't specific, or either general or specific enough, is that there may be property that someone will claim was not disposed of in the will. And so that is another reason why there's both specific and general provisions. And then the will needs to be dated and signed, and the usual was, except in some special types of will, called holographic, where they were all in the handwriting of the deceased, or wills that were given just at or what's called deathbed wills, where there were wills that were dictated or whatever at the time of death. And occasionally these kinds of wills are upheld even though they lack the formality of the signing of a will. But normally, in order to avoid a contest proceeding, a court action trying to make the will invalid, then it is necessary to have the formal signing of a will. And if you've done a will ever in your life, you know that it's a formal sign each page individually, or at least initial the pages, and then sign and have the signature notarized and have two witnesses sitting there watching you do all this. And that's basically the same procedure that's been in effect for hundreds and hundreds of years. And it's probably not going to change in the future at all. Particularly, we're not going to go to online wills that can be enforced without some kind of formality. Now we're going to return to this concept of having to show testamentary intent. That's the core of a will. That's the idea of what the will is all about. And the wording that's used in most of these is that I intend to dispose of my property upon my demise. And that word demise means you die. It's death. And so that's the statement that will appear almost uniformly in any will or any document that's held up to be a will. Now, this is the current will introduction. I'm going to read this off to you. And this is and this is the way that even if I were writing a will, I'd pull up this will form probably and fill in the blanks and create a will. Now the question is, could I do that for myself? And unfortunately, that's not a question I can answer. That depends on your competency. It depends on the circumstances in which the will's made. And all I can say is the less formality that you have in the making of a will, for instance, if you go online, print off a will form and fill in the blanks and sign it, and then have your, couple of your friends sign it, the answer is you're asking to have that will challenged in court. It's just going to be it's like an open invitation to a lawsuit, which, by the way, is a very good thing for people doing research of your genealogy in the future. The more litigation you have, and the harder it is you have to get things through court, the more it benefits these people who are trying to research your life. So, it depends on what your motivation is. If you would like everybody to be fighting over it and thereby create records and documents for the future researcher, then we will be grateful to you, but your heirs probably won't. The current introduction reads something like this: I, giving the name of the testator, of such and such a location, including the state, being of sound, and even the country in some cases, being of sound mind and memory, do make, publish, and declare this to be my last will and testament, hereby revoking all prior wills and codicils. Now, the word codicil means an amendment to the will. So when you add a codicil, that's the technical term for, wait a minute, I didn't really want to give all that to Aunt Mary, she just died. I really want to give it to Aunt Jane until she dies. Maybe I'll wait and see if she dies before I change my will. No, this is the kind of thing that you go through with the wills all the time. We have, by the way, did have people who came in, and every time somebody said anything to them crossly, they would come in and change their wills. So, they would have 6 children, for example, and depending on who called that week, they would come in and change their will to whoever had called that week. Yeah. But it was fine with us. We were glad to try and dissuade them from doing that, but if they were intent on doing that, we really didn't have any other choice. Now, why would I say make, publish, and declare? Well, actually, if you think about it long enough, which lawyers have a tendency to do, they're all 3 different things. And so when you make a will, that doesn't mean you ever published it. And if you publish it, it didn't mean you declared it. Believe me, that's the kind of thing that we can argue about. But this is what you'll generally find in even somebody who is a proponent of modern will language will probably still be stuck with this kind of wording. Now we're going to look a little bit back. The oldest surviving Anglo-Saxon charter was issued in 679 AD. And these charters are a series of documents that are preserved, that somehow have been preserved since that time period, and they include wills. And those wills, even though they are in Old English or in Anglo-Saxon, really are just about exactly the same as they are today. Here's a will written in 1682. Now, not too many modern wills invoke the name of God. And we're going to come back and look at this a little bit with a little bit more critically minded. But basically, this is the same language that, except for the introduction here about the King of England and all that stuff. It's really the same things that you would read in a will today, except for the fact that you say this person is saying that they're very sick and weak, but in perfect memory do make and ordain this my last will and testament in manner and form following. Okay, so that's another way of saying the same thing about make, publish, and declare this to be my last will and testament. That's the same exact statement with a little bit of difference in the wording there. I said I'll come back to that, but before we even do that, we're going to talk a little bit about the formalities of looking at some of these old wills. The first one you want to look at is the Thorn. You may or may not recognize that. It's the word ye, like in ye oldie shoppy, that if we want to make everybody believe that we're getting back into something like the Middle Ages or whatever, and you still have English, of course, you're going to use a lot of ye's. By the way, the word ye is pronounced the. So it is not ye, it is the. And it's using the thorn. And the thorn is a letter used in Old English, Gothic, and Icelandic. Well, modern Icelandic, but it's still used in Icelandic. And this is what a thorn looks like. And it was just an extra letter in the language, and it stood for the sound we have as th, the sound. So this is the basic. This is a letter that you'll see all over the place as you get back into the 1700s and 1600s and whatever. And by the way, ye, which is the word ye, not the with a thorn, but the word ye is the second person plural personal pronoun in the nominative of Middle English. So when you use the word ye, you're actually, the second person plural would be you all in English today. So that's kind of the way that you're doing it. Now, fortunately or unfortunately, this particular form of word has come over into liturgical English today. so that people use it in the context, primarily because it's used in the King James Version of the Bible, which was written a long time ago. Okay. The other thing is lists of these online. If you want to look at lists of will abbreviations, just put in Old English or Middle English will abbreviations. So what you have here is a lot of just general terms. And if you look, there are like dictionaries of the old abbreviations that are used. But in addition to that, you have abbreviations that are made up by the person writing the will. So those are a little bit more difficult because they may be something that is not current, doesn't show up in anybody's dictionary or list of abbreviations. And so you need to kind of look at the context of what's being said in the will and to decide what that abbreviation might mean. The last ones are very simple, and those are the ones that they use to save ink. You can sometimes tell the economic status of the person writing the will based on the number of abbreviations, because if there are lots and lots of abbreviations, it means that they didn't have enough money to buy very much ink. That's really true. I mean, I see that in old parish registers and other old documents all the time. Okay, so let's go back to that old will that I just did, and hopefully these little markers, we were having trouble in transcribing these from one format to another. Let's see if this works. First of all, we have ye, which is now the. So in the name of God, amen, the first day of April, in the 34th year of the reign of our sovereign Lord, LD, Lord Charles II, by the grace of God, England, Scotland. And then we have down here, defender of the faith, and etc., etc. And in the year of whatever, go here, France. And you have the FF here. The reason why this is an FF is a little bit complicated because it's really a word, the capitalization of France. It's a way of showing the capitalization of the FF. And they described it as a double F because that's what it looked like, but it isn't necessarily a double F. And then we have our Lord God. You would wonder why they would abbreviate a three-letter word, but like I said, there was reasons. Sometimes they just did it because they did that, and sometimes they did it to save ink. So that's about as simple as it comes. Then when down here, make and ordain. The word ordain is the same as in the modern sense. And then we have one more here. Oh, we have two more. Parish. This is PSH, and it's Parish of Kirklington. In the county of Oxford. And so there's all these kinds of things that are going to make a big difference in the way that you understand how this will is going to affect this person's property and what they're intending to do and where they actually lived, as a matter of fact. So these are kinds of things that are helpful to understand. Now let's go on to some other important notes. I guess those notes didn't get, that. Of course, you'll have to deal with the handwriting. The main issue here is that we have a long list of, we have a lot of changes over time, and the further you get back in time, the more difficult you'll find the language, the handwriting to be. There are different styles of handwriting that go back into the Dark Ages, in the Middle Ages. The time frames here, most of the handwriting, and this is another issue that's altogether interesting, and that always comes up in this context, is that currently most of the young people in our society are not being taught how to read cursive. They're not even taught how to write cursive, much less read it. And young people that I've gotten involved in looking at this, for example, one of my grandchildren came in to help me do some putting some photos up online, and I brought up a document that was handwritten by my own father, and I showed it to him, and he looked at it and said, "I can't read that." And I said, "Well, it's written right there in plain English." And he said, "I don't recognize any of it." And so I explained to him what it was saying, and then he said, "Well, yeah, I can see that now." So this is not anything unusual, but for genealogists who are working with historical documents, the further you go back in time, the more likely it is you're going to encounter handwriting script that is difficult to read simply because of your lack of familiarity. As you go back into the 19th century and the 1800s with handwriting, sometimes you already begin. Of course, what we have is another problem, and that is that among those who were writing those particular old documents, there were people who had good handwriting and bad handwriting. Even if the letter changes and the shapes of the letters changed over time, it was still a matter of fact that some of the people couldn't write very well, and they were not just they were unfortunately sometimes parish priests and the lawyers who were drawing up the legal documents. So this is sometimes they would employ professional scribes to do the writing of the final document simply because they had good handwriting and people recognized that it was good. So we have to deal with handwriting as we go back in time. But as you're working through a document like this, what you have to do is look at and see if there aren't the same phrases that you're now used to if you've been working through some of the wills that are more current. So you'll look there, and part of this particular document is torn off, but it does say, "In the name of God, amen," on the 5th day of May, and the rest of it's cut off here, and then it says, and so forth. Anyway, now, going back even further in time, as you get back into the early 1600s and the 1500s, you will start to find more and more of the document in Latin until at some point in time you will find the entire document written in Latin, and there will be very, very few documents that aren't in Latin. So these are some of the challenges of moving back into the very much older wills. Now, the key here in getting yourself through all of this is to use a legal dictionary. And there is one. Now, there are others, but this is the legal dictionary that's used by virtually everyone who practices law in an English-speaking country, and it's called Black's Law Dictionary. It's in about its 10th or 11th edition, and it is online now. There is thelawdictionary.org online, and you can look it up and look in and put in a word that you don't know and get the Black's Law Dictionary meaning of that word. Now, from a genealogical standpoint, the question I get occasionally is, well, should I run out and buy a copy of Black's Law Dictionary? Well, you could, but like I said, this is all online, and it's just as easy to type that in. In fact, what's even easier is that online on the Internet Archive, that's archive.org, there's a complete text of the 6th edition. Now, the thing about this particular in this particular subject, particularly the way that the conservative nature of the legal language, is the 6th edition for genealogist is just as good as the newest edition. There's no reason that an old one, in fact, if you found a Black's Law Dictionary that somebody was trying to give away or get rid of or sell for cheap, you probably are well served by even some of the older dictionaries. In fact, if you really want to know, you can go back to the first edition of Black's Law Dictionary, which was written clear back in the 1800s, and is probably about as helpful today for a genealogist as the newest edition, because it's really just the really, really old terms that are very difficult. Most of the other language is pretty well is pretty easy to decipher. Now we have to understand one legal principle that is extremely important in law and applies to wills and the language in the wills, and that's a principle of law called stare decisis. That isn't the way it would be said in Latin, but that's the way we pronounce it generally around here. But what stare decisis means is that it's called judge-made law, and it's very conservative. In the English law system, which was adopted generally in the United States, the idea was that there were two types of law. One type was the statutory law that was implemented by legislators. So the legislatures would sit down and draft up a law that said, okay, you can only drive 55 miles an hour on this road, and you can drive 60 miles an hour on this road, and etc. But in another sense, there was law that was created by the judge's decisions. Now, we're not just talking about judges who were local or people who, anybody who just happened to be a judge. We're talking about the judges who were what are called courts of record. Those are courts of appeal and the Supreme Courts throughout the United States. Every state has a state court of appeal and a Supreme Court, and we have in the United States district courts of appeal, which have the position of the appellate courts in the federal system, and also the United States Supreme Court. Well, all of these courts record their decisions, and they usually explain why they made the decision that they did. This body of law is called the judge-made law, or stare decisis. It's the law upon which future decisions are made. So if one judge makes a decision a certain way, another judge comes along and says, well, I'm going to do the same thing. Once a few judges have made the decision the same way, then the law becomes what's called a precedent. In other words, from that point on, attorneys going into court can argue that the judge should and has to rule in a certain way because of all these previous decisions that have been made. So the part of learning the law, most people think that learning the law is to sit down and read all those the books full of the laws, like the legislature's laws that come out in what's called the uniform state legislature, the uniform laws from those states. Yeah, no, it's nice to know that, but you don't want to try to remember any of it because the legislature changes it every year and you don't want to be stuck with the old stuff. The same thing here, though. The judge-made law changes very, very slowly, but does change over time, but only very, very slowly. In fact, some of the rulings, not unusual, by the way, for an attorney like me who was in court continually, to cite cases that were 100, 200, even 300 or 400 years old. Is not very unusual that I would go back to laws that were some of the earliest English laws made just after the Magna Carta. In fact, I have been in cases where we have argued clear back to the Magna Carta in England. So this is not the end of the law. Never seems to end. It just seems to get bigger and more complicated. So what would happen if the wording of a will changed? It would mean that the whole law concerning that particular that statement that was made in the will would have to be reevaluated. And that's just not going to happen. So an attorney who, if attorney thought he could be really innovative and come up with new language for a will, the first thing that would happen after they took it into court and found out that there was all these problems is they'd probably sue the attorney for malpractice. So basically, there's a provision. It's not just a question that everybody wants to do the same thing. It's basically that everybody has to do the same thing. So all these cases and all of these laws are in existence simply because of this way that we have already evolved of making laws through judges' decisions. So in the law, old is good. The older it is, the gooder it is. I know better, but that's the way we do it. Now, obviously, words, grammar, and spelling change with time, and these are another challenge that you're going to face when you look at a will. It would be impossible here in an hour or any length of time to go through and show all of the changes that might occur in the way that the will was established. So I just looked, for example, and found that the earliest will on FamilySearch.org in the historical record collections is from Maryland in 1698. Considering that the Pilgrims landed in 1620, and further considering, well, Jamestown was in 1605, and then we have people showing up in great numbers. It's surprising, actually, that we don't have a will before that time, but it is preserved and it is available. And I'm sure there may be some older ones in some of the archives back east, but this is the oldest one I could find on Family Search. And here's the 1698 will. And if you look at it really closely, it says, "In the name of God, amen. I, James William, being of perfect sense and memory, God be praised for it, and calling to mind, knowing that it is appointed all men once to die, I do by these presents formally made, either verbal or by writing, and do hereby make ordain my last will and testament in manner of form following, viz." And anyway, it goes on and on. A little bit more flowery than we would use today. We take out a few of the extra words that really don't add any legal or meaning to it, but this is the same stuff we say today. And that's the bill back in 1688. Now, the earliest wills in recognizable form, if we go way back in time, date from the late 13th century. Now, I said there was wills going back into the 6th century, into the 7th century, 600 AD, but you'd have a hard time reading them because they were written in Old English, really Old English, and Anglo-Saxon English, and so they're in a very much formal language. But what you can recognize comes from about the 1200s. And if you want to read any of these, there's what's called an online international bibliography of medieval and early modern wills and probate inventories. So you can go in there and find a list of all of these old wills. And it's basically a listing of all of the documents. Then you'd have to go out and search for the documents, but this is a list of all those old documents. And here's the link to that. It's Belmont University campus, so campus.belmont.edu/honors/willbibhome.htm, and that is a website that lists as many of these old wills as they could possibly find. Now, we're going to go back to our will transcription and come up with some more of that, of the words in that, and a little bit more about what kinds of things you might want to know about if you're going to get back into understanding what happened with the will. one of the things that used to happen when I went to court was we would have frequent hearings. That would mean I would have to appear before the judge for some reason, usually having to do with some procedural issue in the lawsuit. Um, and I would, as a matter of course, always give my clients notice that I had to attend a hearing. Well, many of my clients who were unfamiliar with legal processes would say, well, I'm supposed to be there, and I'd say, well, no, you don't really have to be there. Of course, if you want to be there, you're welcome. I'm not going to keep you out. You know, it was bad form to try to tell somebody they couldn't go to court. So they would show up, and I would go through the hearing, and then they would walk out the door, and the first thing I would hear from my client almost invariably was, what happened? What was all that about? Well, this is sort of the situation you're in when you're faced with a will. You can read through it, and sometimes you go, well, what was all that about? Who got what? And in what you would probably have to do is the same thing that a law student would have to do when they were first learning about the law, and that would be to sit down and diagram it. In other words, try and figure out, make first sure that you know from a dictionary the meaning of each of the words. You need to know, make sure you know exactly what this word means. You don't just gloss over legal terms. And if you think that this was not something that would happen, then you understand that I had a copy of Black's Law Dictionary sitting on my desk for the entire 39 years that I practiced law. So, you know, you're never going to get away from this. So let's look at some of the terms. Bequeath. That's one that shows up all the time. And basically a bequest, or the verb here is bequeath. You bequeath a bequest. Is to leave a person or another beneficiary by a will. So this means that I first bequeath my soul into the hands of God, and then they start talking about what they're going to bequeath to the rest of the folks. Okay, here is Michaelmas, or Michaelmas, and that happens to be a holiday. It is the Feast of St. Michael on September 29th. So this is the kind of thing that you can't gloss over, because this is what's going to happen here is this helps you to date the context of this will. And one of the questions, of course, you might want to know is, when did this person die? And if you see these kinds of clues, if you will, or indications in the will, it may help you to understand what was happening in the family, and who died when, and what was going on. Equally divided. Now, this is an interesting concept, because you can equally divide goods. Well, how do you equally divide, for example, if you have a saddle and a yoke of oxen, how do you equally divide the yoke of oxen and the saddle? Well, the court solved most of this by selling the stuff off and giving the people the money. And that's really the practice that happens today. If there's a question about dividing up a property equally, then the property is valued, and if it can't be physically divided, then it is sold and the equivalent money is given to the heirs. So these are some of the provisions that you'll see all the time. Here's 5 PDS, that's pounds. And of course, if you're going to get involved in this, you need to know the monetary system that was in existence at the time. You might want to know how much 5 pounds was when this will was made. It would give you an indication of how much money these people had, whether that was a lot of money or not very much. A lot of times today, if they want to cut somebody out of a will, they'll leave them $5 or $1 or something, because the concept here is that if you cut them out entirely, then they can argue that they were left out unintentionally and challenge the will. But if you leave them something specific, even if it's just $5 or $1, then that was showing that you thought about it, and this is really what you wanted to do. So this 5 pounds may be that being paid to this Abraham John Abraham, joint executors, this John Abraham person is maybe just simply to get rid of him. In other words, he's not getting anything else. And other legacies. This is the legacy is what is given in the will. So anything that is included in the will is the legacy. Up, back. So that's money or property left in a will. I can't emphasize this more that than by saying it and repeating it perhaps, but every part of the will is important. There's nothing unimportant about any provision. It may appear, for example, if I were, after having read literally hundreds, perhaps thousands of wills, if I looks like I skipped through it, well, I'm probably skipping through it because I know all of the what you might call boilerplate, those kinds of provisions that are standard in all the wills. But in the end, I'm going to have to go back and read it very carefully to make sure that I understand who gets what and what the conditions are, if there are any conditions expressed in the will. So you need to be very, very aware of each part of the will as it's created. In this case, to call that attention, this particular will, they wrote it out as putting the word item at each of the paragraphs that they wanted everybody to take notice of, is what they specifically wanted to do. As I said earlier, when you go back far enough in time, you'll always find Latin in Europe. And here's an example of some of the old, not only just old script, but old script in Latin. It's, once again, understanding that a lot of that I read in that one introduction, the one brief introduction, are helpful in making sure that the person had testamentary intent, that they really did want to give away their property when they died. And secondly, they were to conform with whatever degree of formality was required by that place where the will was made at the time. So you're going to see a lot of things that are expressions of intent. They seem like repetitious, and they'd say, well, how necessary is it? Why does it have the language that says this over and over again? The answer is that the more this was said, the more likely there would not be a it's more likely that there would not be a contest of the will, that people would not come forward and try to overthrow and not do what the testator intended. Declare, constitute, and appoint. So you're going to see these phrases used over and over and over again. Aforesaid. Aforesaid is really starts sounding archaic today. But instead of saying aforesaid, we would say something like as I noted previously, or some other phrase. So it's really quite a nice word, but it makes it really strange if you throw it into current speech. Oh, can't help it. Jointly. Jointly is a catchphrase here. You really have to understand that when you say something is jointly done in a legal sense, it means that particularly when it's expanded and says jointly and severally, which is a legal term, the jointly and severally part of the will means that each individual is considered as an individual, but altogether they're considered as one unit. So you have what's called a joint tenancy, where a person is a part owner with the other joint tenant. So if you had two people who had a property by joint tenancy, they each individually own 100% was in joint all sorts of situations as an undivided part of the whole property. So you have to look at anything that happens after that as if all of these people were one owner. Give and bequeath are two different words, because bequeath implies a bequest. Give means you're actually giving possession of the property to someone. So it may sound like I'm saying the same thing over and over again, but believe me, if we were in court, there would be a difference there. Give and devise. Now, you can give, bequeath the property, but you can also give and devise the property. A devise is basically a provision to give a portion of the property, usually money. Okay, here's some other expressions that come up. Appurtenances. You'll talk about my farm and all its appurtenances. The word appurtenances means everything that goes along with the farm. So if I gave someone my farm and its appurtenances, that would mean they'd give them the barn and everything else, the cows and everything and all the equipment, everything that went along with the farm itself. If I give them the farm and none of the appurtenances thereto, they might just get the raw land. My decease. They talk about my decease, my decease is a kind of an archaic way of saying when I die. So if I say, it's a lot of times attorneys would try to play down the fact that the person was going to die any minute. It was bad form to walk in and say, you look like you're going to pass on any minute now. Why don't you do a will? You would talk about it in a little bit less abrupt ways. Share and share alike. Okay, this is another catchphrase. When you're talking about property being given out to share and share alike, what that is that they become what is called tenants in common with the property, if it were real property. But if it's other property, they're all joint owners of the property, but they have a percentage interest, and what you're tell them is share and share alike is that all of their interests are the same. So for example, I could create a tenancy or an ownership of a property that was like a common tenant, having tenants in common or property in common, that everybody had a different share, a percentage share of the property. But if I say share and share alike, that means that everybody has the same percentage interest in the property, whatever kind of property it is. It's sealed and declared, and usually there's also a word signed, sealed, and delivered, although it's not necessarily necessary to deliver a will to anyone. But to declare a will is a legal provision that indicates that you have actually made the will intentionally. So this is another expression of intent. Signed and sealed means that you signed it. The seal is no longer necessary. That's in the old days, though. You actually affixed a seal. That would be a wax seal with an impression made in the seal that indicated that this was a legal binding document. And in some documents, even up until the time when I began practicing law, still had to be sealed under the law of the state of Arizona. But that was abolished after just a few years after I began practicing law, and they stopped the requirements for sealing of anything. Even the corporate seal was not necessary back further in time. But we'd like to thank you for watching, and remember that this is part of the Brigham Young University, or BYU, webinar series that appears on the BYU YouTube Family History Library YouTube channel. And remind you that you can subscribe to the channel and receive notification of all the webinars that are upcoming. And we have quite a few planned this month. And if you go to the BYU Family History Library website, that's on byu.edu, you will find a current schedule of all of the upcoming webinars. Thank you for watching.